Hello, everyone. Thank you so much for joining us today on Destinations International's last webinar of the year for our members. 3 things every marketer should be asking their data partners. My name is Kate Skidmore. I'm the Senior Director of Membership Engagement. I know many of you on the call, so thank you so much for joining us. And those of you that we have not interacted with before, we're thrilled you're here. So today we are joined by our partners and friends at Arrivalist. We have Cree Lawson, our founder and CEO of Arrivalist. Hi, Cree, how are you?
Doing well, thanks, Kate.
Excellent. And Cree will do introductions in just a moment, but a few housekeeping notes. This webinar will be recorded, and I'll also be monitoring the question board. So we'll open that up at the very end and give you a chance to unmute and ask the great team today any questions or comments that you might have. So Cree, with that, I will throw it to you. Thanks so much.
All right, thank you, Kate. Appreciate this opportunity. I want to say thanks to Destinations International for this opportunity, and thank you. We've had a really amazing turnout for this webinar, lots of interest, and thank you to everybody who dialed in for asking the hard questions, being willing to ask the hard questions. You know, a lot of what we're going to talk about today relates to data privacy, legal, and we're going to take an unflinching look at all the hard questions that reply to data and how it should be used today. So as Kate mentioned, I'm Cree Lawson, founder and CEO of Arrivalist. I've spent about 21 years, I tallied it up the other day, 21 years working in online travel marketing and online travel media. And some of the best years of that career have been starting Arrivalist. Paul Godinez has been an advisor since the very beginning. Paul has advised Arrivalist as we've tried to be ahead of the curve, proactive in approaching all things privacy and data related. And I've asked him to join me here today to talk about privacy and CCPA, which clients are asking us about at the rate about 2 to 3 times a day. So Paul is not just an attorney, but he's also an entrepreneur himself. He's founding partner of Bailey Duquette, and I'll let Paul give a little bit of his background, and then we'll jump into the webinar.
Thanks a lot, Cree. So, yeah, Cree mentioned I'm a partner with Bailey Duquette. I've been practicing for close to 19 years. My practice has always been a focus on IP and privacy issues. In particular, I've been working with Arrivalist over the years on privacy-related questions. The CCPA is a hot-button topic, certainly this year and going into 2020. We'll go into a little bit of the mechanics of what the CCPA requires and what businesses and service providers need to be thinking about.
Great. So it's not just going to be about CCPA, but we want to bring in our expert on this topic. We're also going to cover other hard questions you should be asking your data provider. But we're going to lead off with that since that seems to be the hot button today. What we prepared for you today is 3 hard questions, which will address CCPA among them. And then at the end, we've got a little bit of information about what action you can actually take on this. So here at Arrivalist, we like to keep it lively. We like to mix it up a little bit, keep it interactive. So I thought I'd throw this out there, make this an interactive webinar, kind of a lean in rather than a lean back webinar. So I'm going to throw a question out there. So if you've got the chat box open, or if you've got the question box open on your screen sharing software there, then feel free to jump in with your answer, your best guess at this question. Pop quiz. How many websites in the United States are compliant with the European Union's GDPR initiative? That took effect May of 2018, so almost exactly 18 months ago. And just wanted to throw it out there. So feel free to enter your comments into the chat box. Those will be compiled by Katie, and we'll see how close we have to be to getting a winner. What's the percentage of websites in the United States that are compliant with the EU GDPR? So while you're compiling your votes, I think it's probably helpful if I give you a quick overview of who we are and just so you know our perspective on this. At Arrivalist, we built a new lens on consumer behavior patterns. We look at consumers through the lens of the movement of their smartphones. So historically, you might see breadcrumbs that travelers leave behind, certain transactions on this, certain transactions on that. We've built out the ability to put together the whole picture, and movement data provides kind of the fabric so that you can stitch together the whole visitation experience. You know, we started quickly in 2012 with measuring whether people showed up based in a place after seeing ads for the place. Really simple concept, and is really, we started commonly known as attribution. We quickly realized we were onto something much bigger, and as we've grown the company, we've really expanded now to grow with the industry. So clients are using our data. You may know us for attribution, but clients are increasingly using our data for destination development, for destination advocacy. We're doing studies these days to help destinations figure out how to make a case to build a new convention center. So we're really involved with the industry, leveraging this data set. One more slide based on the technology and how it works. So we see 120 million smartphones moving around the US and Canada. That reveals visitation insights about where people go, how long they stay. And we started with tourism boards, but today we serve 40 to 50 states, 90 plus cities, brand USA, but it expanded. Thanks to your tourism board support, we have expanded, and today we work with 4 of the top 10 US theme parks. We work with large casinos. We work with more than 10 tourism attractions. You should know, and you may not be aware, that we are starting to work with airports as well, just to leverage this massive data set. So that's the lens through which we see the world, and it's, you know, our success is your success. We came from the tourism industry. We are funded by your business. We do not have external funding. We're not venture capital backed. We're not Wall Street backed. We were built with your support, with you, for you. And so thank you for being a wonderful Arrivalist customers and a great place to grow our business. So with that having been said, that's who we are, quick as I can so that we can get on to the meat of the agreement. So let's go in there. Katie, what are the, any guesses on number?
So it's all
no guesses.
Based. We've got a few percentage-based guesses, less than 10%, 15%, best guess 10 to 20, 50%, an estimate of 555, or 35%.
Wow. Okay. Whoever said 35%, you nailed it. Congratulations. 35% of the websites in the U.S. are compliant with GDPR nearly 2 years after it took effect. So whoever guessed 35%, you win. Prize to be determined later.
So maybe we can unmute Kim at the end. She's from Oklahoma. So good guess, Kim.
Way to go, Kim. So good job. So there are also estimates that put this number as low as 28%. So this is, I quoted my source here at the bottom of the page. I'm a good research report writer. Unfortunately, there's more regulation and complexities on the way, and we're going to get into that a little bit. But first, let me set the stage. For those of you who are asking the hard questions, we want to throw out the three hard questions that we think you need to be asking any data provider you work with. The first, as you might guess, is how do you make sure that you're compliant? The second is, how do you measure your data for accuracy? We've got a case study here that I think you'll find entertaining and interesting, but it really underscores the value of accuracy in your data. And then how do you measure the quality of the data that you're collecting? Once we're through all of that, got an addendum, if you will, on how you can take action on some of this data, an initiative that we're starting at Arrivalist. But first things first, we want to drill down on this. We had compliance as number 3, but we just had so much interest in this topic that we made it the number 1 topic that we'll cover today. So I'm just going to dive right in to compliance. There is one mega trend going on in the world of market research. We are moving from measurement of what people say to what people do. What people do, analytics, is a wonderful complement to what people say, surveys. And in fact, a lot of our clients are finding that when they go to their stakeholders with what people say, their traditional foundation and survey data, and then add a layer of what people do, it can be a really compelling one-two punch to prove the impact of tourism marketing. So if you told your stakeholders what people say they do, and then follow up by showing what stakeholders what people do, you can build twice as much validation for the impact of marketing. It's really created a profound new opportunity for tourism boards to combine these data sets and have 2 layers of validation and marketing campaigns. But the mega trend here is changing from what people say to what people do. The headwinds we're all facing in analytics is that it turns out people want to have a say in how you measure what they do. And that just puts it in the most simple, succinct terms that I can think of to put it in. And the ownership of data, use of data, has become a powerful asset. Also got a little bit of liability with it. So with the power of data comes the responsibility for possessing it. So this is what we're seeing manifest itself throughout the industry. Big data is powerful. Big data, possessing big data, exploiting big data requires responsibility. Now, I'm going to give you 2 perspectives on this. One is my perspective as an entrepreneur, as someone who's worked in this space, as somebody who's read all these agreements, and I'm going to take a very practical look at the application of this and why this is happening. Paul is going to be able to back me up with a legal perspective here. I want to make clear, disclaimer inserted here, that I'm not an attorney. Whatever you hear me say should not be considered legal advice. But it's pretty safe to say that over the last few years, if you're in the data business, possessing it or extracting it, it's easy to feel like a little hot under the collar, because you've had GDPR, you've had CCPA, there's House Bill 4390 in Texas, there's a bill being considered in New York City, there's a bill that's been passed in San Francisco. This is spiraling. And it seems like every different geography is passing a new compliance initiative. So I want to first, why is this happening? One, we've got a log jam in Congress. You may have seen that. And we're having the advertising industry is having a hard time passing through a national program. So the individual states and cities are stepping up, are passing their own programs, and a couple of things could happen here. One, CCPA could become the de facto privacy regulation for the U.S., or individual geographies could pass their own privacy protections, in which case it is completely conceivable that we could have different privacy policies for almost every state. In that case, the end result would be something like your lottery situation, where you can run a lottery or you can run a contest in these 23 states, but not in those 15, and it can become a real patchwork. I'm hoping that's not the case, but we need to be prepared for that eventuality, especially if no privacy policy passes at a national level. But that doesn't mean that we should throw out the whole thing. The only way to deal with privacy from my perspective is to look at the basic tenets of what's going on and You don't try to react to every single law. Rather, plot a course that addresses the fundamentals of the issue. So what is going on here? So it's companies versus consumers, basically. Companies want to use big data to measure what people do. And people want to have a say in how that happens. Consumers want more transparency. Consumers want to be able to opt out. Consumers want to be able to reject the sale of their data to third parties. And governments are increasingly providing those rights, and the penalties for breaches are escalating. The big change that CCPA puts on the table from my perspective is that CCPA allows a user to delete their data, and it allows the user to prohibit the sale of their data. So overall, people want to say in measuring what they do. If you want to go beyond the alphabet soup, there are basically 5 tenets for all these initiatives. This is my perspective again. 1, they want to prevent breaches of existing personal information. Breaches is a key thing here. Number 2, they want to give the consumer notice and consent. Number 3, there is now a right to be forgotten. The user wants to be able to delete their data, and they want to be able to not have their data sold. So that's those are the 4 tenets here, and those are a common thread between, in my mind, all of everything that's been out there. So if you craft a strategy on these pillars, I think you'll have something that will apply to all of the different initiatives. So how did we get here? One more quick thing on the history and how we got here, and then I'm going to hand it to Paul. You know, a lot of this becomes really complex when you take it outside of the story. If you read it as a single act, CCPA can be a bit befuddling. So it's important to remember how we got here. So 1970, Fair Credit Reporting Act protected personally identifiable information. That's the first use of that term. And it protected the stuff that today we would call a no-brainer, things that you shouldn't share with third parties, like your social security number, your credit card, your passport, date of birth, phone number, driver's license, that type of stuff is now protected information as of 1970. So then a big question emerged. How do you handle? What are the rules of play for this personally identifiable information? So privacy policies emerged, and that the basic tenet for the last 30 years was if you do what you say you're going to do with your data and people's data, you're basically okay. Just don't do anything that you say you weren't going to do. But then a big question jumped up. Are cookies personally identifiable information? What about browser history? What about IP addresses? Are IP addresses PII? What about location data? That PII? So the first legislation to jump in and make a decision there, GDPR, 2018. GDPR says, does not decide whether cookie data is PII or not. It just says it's protected as personal data. So GDPR is the first initiative that protects cookie data, IP addresses, latitude, and longitude. This sets off a sea change and then of course in 2019 you've got CCPA, which also protects cookie data, IP addresses, and location data. This sets off a sea change. Up until GDPR, we were in the era of opt-out. Place a privacy policy, get a user the ability to opt out, and you're done. Don't do what you say you're going to do with the data, you're fine. Now we're in the era of opt-in. GDPR makes it required that a user gives notice and consent. CCPA makes it required that the user gives notice. And so with the opt-out becomes opt-in, basically street translation, that means more pop-ups for everybody because you have to opt in and get notice or opt in. But CCPA adds 3 more layers to that. 1, consumers can review and delete their data. That was not a provision of GDPR. 2, consumers can prohibit sale of their data to a third party. And then number 3, notice and consent in all applicable languages is required, or notice in all applicable languages. We'll can get into the details later, but GDPR is heavier on consent and CCPA is heavier on notice. That's why, at the end of the day, what you may see, what the rest of the industry may see, my opinion as a lay business person, is that at the end of the day, you may see more legal bills and more pop-ups. And that may be the net result of CCPA. Pretty much how most people would sum up GDPR. But there are important provisions here that should not be ignored. So that's my overview. As a layperson, as a business person, I'm going to hand it over to Paul to talk about, from a legal perspective, what is the impact of all of this. Paul?
Okay, thanks, Cree. I think with that very good overview of how things came to be, I really just want to focus my comments for this webinar on the CCPA and what the requirements are being set forth that businesses are going to have to apply. And we're going to get into, in the next few slides, who CCPA applies to, what the requirements are that you need to put into effect that really change the operations of how you run your business, and other considerations. So we'll jump to why is CCPA important? Why does it matter? Well, with the California Consumer Protection Act, California enacts in January, what you have is providing for California consumers 5 rights. Consider them a bundle of rights. You have a right to notice, a right to access what data has been collected about you, a right to opt out of the sale of your data, the right to request the deletion of your data that's been collected, and also a right to equal services prices. So you can't discriminate against people who come to you and ask for, and want to enforce their rights under the CCPA. So we'll talk a little bit about all that. So the CCPA, as noted, significantly increases the responsibilities of how you handle your data if you are a business. Now, I think what we have to do is talk about, how does the CCPA apply? CCPA, applies to businesses that collect a California consumer's personal information. And there's a test that applies for what is a business. A business has to be collecting data and determining the purposes of processing that personal information. And it meets, one of 3 thresholds, where it has a gross revenue in excess of 25 million, or it buys, receives, sells, or shares personal information of 50,000 or more consumers annually, and or drives 50% or more of its annual revenue from selling personal information. All of this is important, and I think as you look at the CCPA and whether it applies to your business, you're going to need to talk to your counsel, your lawyers, and make a determination as to whether or not you need to get a better understanding for how the business operates and whether the CCPA comes into effect for you. I think one important note for nonprofits and for governmental entities, the definition of business in the CCPA includes the requirement that this is a business that is organized or operated for the profit or financial benefit of shareholders or other owners. And just by those explicit words, it would not apply to a not-for-profit or for a government entity. But I think what's also important, and what you need to talk to your legal counsel about, is the fact that, in addition, you have to take into account whether or not an entity, in fact, controls or is controlled by a for-profit entity that would be subject to the CCPA, or it operates under a brand name that you share with a for-profit entity that would be be subject to the CCPA. So, for example, if you were a co-branded corporate foundation, the CCPA would apply. So I think, given those parameters, it's important for you to talk with your counsel to determine, whether or not the CCPA is going to come into effect for your business. Now, as we drill down here, I think it's important, and I think we'll reemphasize the point that possession of data, equals liability. You need to remember that you're responsible for the data that you collect. You have to be conscientious about what you're collecting, the notices you provide at the time you collect the data, and then more importantly, as you move forward, if consumers from California come to you and request information about their data, you have to have the ability to track it and provide responses to those consumers and delete their data if they request it. I think another important point on this slide. While the law comes into effect in January, very likely enforcement will not begin until the summer, and that's been noted by the California Attorney General's office. But big legal disclaimer: the enforcement action can certainly take effect and apply to businesses beginning on the date of the law taking effect in January. So it's much better to start the compliance processes now rather than later.
So if you put this in plain man's terms, you could get a speeding ticket for January 7th, even if they don't hire cops until July 1st. Is that a fair analogy? Or?
That is a perfect analogy.
Okay.
Yeah. Okay.
All right.
And as noted, notice is required. We'll get into a little bit of that. And then, as Cree mentioned, all languages and disabilities. What we're talking about here is, when you provide notice to consumers on your website, you have to do so, at the point when you start collecting the data, which very likely may be your homepage. It has to be easy to read, plain, straightforward language. You have to make it available in all languages in which you sell your products or services. So you need to look at your business and determine, if we're selling services or providing services in Spanish, we'd have to have the Spanish language equivalent of all these notices. For disabilities, this is, you have to make your website compliant with requirements for allowing people with disabilities to access. This is already a requirement under the Americans with Disability Act, but this law reinforces those requirements. So CCPA by the numbers, as I mentioned, for it to apply to your business, you're talking about whether or not you collect, records of 50,000 California consumers on an annual basis. If you were to, if we're talking about the types of data, as Cree mentioned earlier in the presentation, IP address or web browser data, that is considered personal information under the California law. So if you are operating a website and you're collecting IP addresses as people come to your site, the rule of thumb would be, if you're collecting more than 137 IP addresses on a daily basis, very likely you'll accumulate 50,000 visitors in the course of a year. So, the application of that, as a requirement, I think captures a lot of, businesses that exist that are operating today.
So this isn't just email addresses. This is, it's not like if you've only got 50,000 email addresses in your database from California, you'd be exempt. Like if you're setting cookies on 50,000 Californians a year, whether those are set by your ads or your website, then this would apply. Is that correct?
That is correct. So, and as we noted, it applies to the California residents. So, what you may consider doing is geotargeting California consumers based on IP addresses to be able to serve them the right privacy notices as they come to your sites. As we've mentioned several times, the definition of personal information is broad. I mentioned before that what we're talking about with the definition includes not only browser histories, right? We're talking IP addresses, cookies, beacons, any pixel tags. That is very expansive. For the first time in the United States, you have that included in the definition of protectable information for a consumer. So it's going to have a big impact. Just going back to the previous slide, Cree.
Yeah.
A couple of things to note. As we mentioned there's the 7,500 per violation. So what we're going to talk about here is, what happens if you're not compliant? You would face two kinds of situations. One is, if you're not compliant and the California Attorney General's office seeks to, enforce the law, it's written into the statutes that you could receive a penalty of $7,500 per violation. So if you consider how many unique visitors from California that may come to your site, those could add up very quickly. It could be very be very costly to businesses if they don't seek to comply. There's another provision of the law that provides for consumers to be able to sue under a private right of action. We'll talk a little bit more about that, but it's a very limited, narrow scope for what consumer personal, private actions could be. Okay. So what's new? Stricter penalties we talked about, and let me talk a little bit here about the civil lawsuits that people have been concerned about since the CCPA was passed. For a consumer to sue you as a business, and this is different from the California Attorney General's office bringing an enforcement action against you. So those people who've been, who on this call, understand the risks of class action lawsuits and the rise of class action suits, in various areas of the law. The CCPA gives a very narrow scope for what those actions could be. It has to be a breach of your data security where you're disclosing in unredacted or unencrypted format certain types of personal information. And Cree mentioned it earlier in this presentation, the no-brainer data. So what we're talking about here is social security numbers, credit card information. So that level of sensitive data is the only applicable elements of personal information that would be involved with a breach that would give rise to you being sued in a private cause of action by a consumer. Tougher standards for storage and data breach. I think we've covered that in terms of discussion, just on this point. For point 3 here, like the requirement that you have to allow users to opt out of the sale of data. And we'll talk a little bit about that. What CCPA allows for a consumer to do is to give you a request to understand certain things about the data collection that you've done to date or the previous 12 months. So what data you've collected about them, the categories of that data, the sources of data that you may have about them that maybe isn't from the collection from your site. So if you're working with data brokers or other sources of data that you may license, you would need to disclose to a consumer that you've sourced data elsewhere. You need to give them an understanding for the business purpose. Why did you collect the data? What are you using it for? And you need to identify the categories of third parties that you disclose the California consumer's personal information to. So for example, you would have to explain the service providers, or companies you work with and why you disclose the data to them. Now, the fourth point, requiring that a user could, provide PII to delete personal information. Well, what we're talking about here, when you receive a request from a California consumer who says, please delete the data you have on me. In order to be able to, to correctly respond to such a request, and you have to do so within 45 days, you need to be able to verify that the person who sent the request is in fact, a California consumer whose information you hold. So, if you don't have enough information collected to date to be able to verify who that consumer is, who sends you an email or calls your 1-800 number, then you may end up having to request additional pieces of information to verify who's made the request to ensure. In fact, it's actually Cree Lawson who requested the information and not Paul Godinez asking you to delete Cree's information. So it's important. It's an important point, and one we can talk about in a bit.
Yeah, I think the good news here, to tease the later thing, is there are some technologies that can accelerate this process. Just kind of covering the brass tacks. What's the minimum I need to do? It can sound very intimidating. We've done a lot of research on this, and I think my thrust here is to take all of Arrivalist preparation and make it available for our clients. Free of charge, and I'll talk about that later. But let's get real. What can I do if I want to obviate the risk of mitigate the risk of CCPA? First of all, it's really simple. Update your privacy policy. Arrivalist clients can write us, get a free addendum from us. You obviously want to talk to your attorney about it and customize it to your needs, but at least you only get charged for editing. not creating a template from scratch. Second thing, pop-ups. Look, they affected, this is my opinion as Cree Lawson, that's the first thing you can do. Notice, give notice for California residents. And that's the pop-up technology, we've worked on that, we've built on it. It's not mind-numbingly technically difficult. If there are any developers on the call, but that we can do. We've done that. We've been that and done there. It's important to note that the storage of data now is a liability. Make some decisions about, I mean, you'll want to store some kind of data, but make smart decisions about what to store and what not to store, and set up compliant processes for an information not to be sold to third party. I mean, most DMOs that I know don't sell any data to third party, so I don't really think this was going to have an impact. That's my opinion. But I think that's the brass tacks here, and then so we'll go through a quick overview here of recommendations on what you can do, and I think that I want to make sure we cover some of the other stuff. So sure. I think I might just speed on along here. Here's your cheat sheet, and we can send this around. How do you give notice and collect consent? We talked about this. There's basically a few steps you can do to mitigate most. You can take to mitigate most of the impact. So that's it for CCPA. I want to hit briefly on other hard questions you should be asking your data provider, and then I want to try to leave some time for questions. So we get this. We get asked a lot of these questions a lot, and we in turn wanted to pass along the questions that we think you should be asking. One is, I think every buyer out there would love, every buyer of data out there or licensor would like to be able to say, I want a bias-free data set. And that's just a really high standard. I mean, there are biases in most data sets. So when you're asking a client or when you're asking a data provider, what are the biases? Don't ask, are there biases? Ask, what are the biases? Because there are biases in most data sets. Some of the most common biases we see are demographic bias. I mean, think about mobile app data. Mobile app data, who provides mobile app data? People who use mobile apps. And who uses mobile apps? People between 18 and 34. So you should expect some kind of over-representation from people 18 to 34 in your mobile app data. You'll probably see that. We go to Elaborate to balance that out, but there's certain things like that. The people who, similarly to people who respond to surveys, have a certain bias as well. So ask, it's a hard question, but I would ask of all data providers, what are the biases and what do you do to even those out? Longitudinal bias, right? Do you have spikes and trends and curves? You know, those are tough. If you want to have a year-over-year insight, then you need to have a steady stream of information coming in all year long. What do your data providers do to even out longitudinal bias? And then finally, geographic bias. What are the, you know, is the panel or the data that you're collecting balanced down to the zip code or down to the state level? If you're working with a data collection provider that's collecting more data in one state than another state, then you're going to get skewed results. Representative, make sure that overall you want your data to remove as many biases as possible and be as representative of all data as possible. And how do you look at, another question is, drill down on the building blocks. How do they arrive at the insights that they give you? So I'm going to give you a real quick case study here from the Popeyes versus Chick-fil-A sandwich war. All right, so we're going to look at the building blocks of this data. So our team was looking at points of interest, how you define a point of interest. And so we wanted to take a look at location data and see, can we measure arrivals at or Chick-fil-A and Popeyes, and how accurate is that information? Now, as many of you know, we don't serve restaurants. We just test it. So this is just a test for us. Our engineers really like chicken sandwiches. What can I say? So we took a look at the data and started asking these questions. So the trick is, how do you define what a Chick-fil-A is? So if you look at the building blocks, a lot of us use what are called polygons. Some companies will use a point and radius. So let's say you're doing you hire companies that have millions, 5 million POIs, 10 million POIs, will often take the center of the place and the radius around it. What what kind of data would that give you for a Chick-fil-A? Well, here's a radius of 100 meters around the Chick-fil-A. As you can see, there's interstate passing by. Here's proximity at 50 meters for a Chick-fil-A. And then we also took polygons where we just drew a polygon around the parking lot. What difference did it make in the data? Well, here's proximity at 100 meters. So in blue are visits to Chick-fil-A, and in orange are visits to Popeyes. Now, the sandwich war promotion on Twitter happened right about here, August 23rd. So you can see, even at a proximity of 100 meters, you can see there was a response to Popeye's launch of their chicken sandwich. Did it have an impact on Chick-fil-A? Not really. Now, when we take the proximity 50 meters, you really see that spike August 23rd. And you see visits to Chick-fil-A. And something becomes really apparent at 50 meters. Every Sunday, there's a dip. Why? Chick-fil-A isn't open on Sundays. People don't go there. So now when we take it down to the parking lot level, where we've got the most parking lot level, now the response curve for Popeyes doesn't change much. You can see there's still a jump up. Popeyes still gets a lot of visits, not at Chick-fil-A's expense, but they get a lot of visits after the social media post about all their chicken sandwiches running out. And so they get a big spike. But look what happens to the Chick-fil-A Sunday. They go away completely. And so basically, if you look back here, all these Sunday visits are noise because they're including people passing by because the polygon has been poorly defined. So those are the building blocks. And I think you should ask your clients on a very detailed level, how do you build the insights that you gather? So overall, I'm happy to say all of these methodologies still measured the jump on August 23rd, where Popeyes gained share on Chick-fil-A, but over time it looks like Chick-fil-A still reigns as chicken sandwich king at this point. So just a little fun case study for you. And then quickly, want to cover a little bit about data accuracy and wrap up. These are the questions you should ask your client, your data providers. And then the second thing you should ask yourself is, how do you source your data and verify the quality of it? You obviously want to find out if they're compliant. Does the user have the ability to opt out? Does the user provide absolute values or just percentages? If so, what is the end value? Consider the source. Now, I can't underscore this enough. We in the tourism industry have had a wonderful experience on the whole with location data. And it's really easy for us. We've been able to take location data to our stakeholders and lobby for more funding based on 2 data sets, surveys and location data. And nobody's really questioned location data in the tourism board space. That has not been the case in retail. Retail, Walmart's, etc., wanted location data immediately. They wanted it so bad, they were 5 years ahead. They jumped in there headlong. They wanted to use location data to measure who shows up at a Walmart or who shows up at a Sephora. And so a couple of early front-runner companies jumped in there and started providing it with something called bitstream data. Well, all those early providers got a black eye for using bitstream data. And then don't just take my word for it. Just go to Bing and do a search for bitstream location data. Do your own search. I took a screenshot for you, but do your own search. Less than 10% of bitstream is high quality. What is bitstream location data? Why is it inaccurate? Confessions of the location data, it's a Ponzi scheme. Like, this is really bad stuff. And we, in the location data industry, we haven't faced that kind of scrutiny because we haven't used bitstream data yet. And we haven't gotten any black eyes for that. But if you ask the right questions about the sources of your client's data, you can avoid that kind of outcome. And so these are my recommended takeaways for bitstream location data. So final 4 minutes, I'll wrap it up. How has Arrivalist prepared for CCPA? There's some good news here. Most laws haven't taken effect yet, 19 days. Most privacy policies, you know, all the changes that we need to make, pretty darn similar. Again, my opinion is Cree Lawson. So, you know, for one of us to do the work to be compliant, pretty similar to what everybody else needs to do. Most pop-ups carry basically the same message. Cost of developing policies and acceptance, you saw it could be $55 billion a year. Collecting consent can be an opportunity to build a deeper relationship. And bottom line, we're all in this together. So what Arrivalist has done here is to work hand in hand with our partners, our clients, to basically share the burden of consent. If one of us is going to build a pop-up, if one of us is going to write a privacy policy addendum, why don't we do it for everybody? So we decided for our clients to offer free website policy, CCPA website policy review, give users notice, help them consent, and we even license a consent management platform, privacy consent platform that we provide free of charge to our consumers. And this will take you, I like to think this will take you a lot of the way down the path. It's just the right thing to do for the industry. We do ask to be named in the consent collection, but that's the only benefit that the Arrivalist derives from this. So the basic thrust of our response here is one unified opt-in, and there's a 5-step process to get started if you're interested in that. But this is not a pitch for that. This is a webinar about how to the 3 hard questions that you should be asking any data providers. And you can ask them you can ask Paul or you can ask me. I recommend Paul because he's smarter. But we're happy to answer any questions that you have. That's it. Over to you, Kate.
Cree and Paul, thank you so much. I think this is such an important topic. I know even internally with Destinations International team looking at GDPR in our communications, it's definitely a hot topic on all of our minds. So I'd like to invite everyone to go ahead and enter in any questions or comments you have. We can also unmute you, and we'd love to unmute the winner of the pop quiz, how many websites in the US are compliant with EU's GDPR, and that was Kim. And Kim, I believe, is with Oklahoma Tourism and Recreation Department. Kim, are you able to say a few words? Are you there, Kim? Oh, I don't think she's able to unmute. Let me just mute her. Okay.
Yeah, any other questions?
Cree, one of the questions we did get is, how are other states handling this in comparison to California?
Yeah, so it's a great question. Several states are considering different approaches. Like I mentioned, Texas. There is, for the most part, the essence of the ones that I've read are similar. Some of them may be a little more, may require a little more consent. So a user may have to consent. Some of them may have tougher penalties. But there's, the CCPA is by far the most advanced, and CCPA stands out because it's already passed. It's already law. It was passed not only by a legislature or the governor. This was a California referendum, and the people of California voted for this. That's a pretty high standard, and it's hard to see any other states getting to the point of passing a referendum-driven privacy initiative. It may well happen. I don't know. Paul, anything you want to add there?
No, I think that's a good way to look at it. The California, I think, as it's been the case is really a thought leader in this particular space. And I think other state privacy regimes that may come into effect are going to piggyback and mimic what California has put in place. So I think whatever you do to prepare for the CCPA will come in handy if other states pass laws. But as Cree mentioned very early in the presentation, all of this could be alleviated if Congress passes a federal privacy legislation that can supplant these individual states in how you need to address privacy on a national scale.
Yeah, and if you want to support that initiative, there's a lot of organizations. I'm fond of IAB, Interactive Advertising Bureau. They're lobbying Congress along with several others, the Mobile Marketing Association and several others. If you want to get behind a national initiative, which will make all of our lives much easier in the future, then I'd recommend putting some effort behind those initiatives.
Great, thank you. We had another really good question. I'm glad this was brought up because we have such a large number, excuse me, of growing Canadian members. But will the GCPR and CCPA affect Canadian-based DMOs that are nonprofit?
Yes, it will. There's an extraterritorial application of the CCPA. It applies to businesses regardless of their location. So if you're a Canadian business or even a nonprofit, you still have to look very closely at the definition of business and the requirements that we talked about earlier, and determine whether or not it's going to be applicable.
Not dissimilar to GDPR, right? GDPR, and this is what a lot of people miss about GDPR, is that it applies to European citizens no matter where they are. And I find it kind of vexing that it's almost as if you have to, it's really hard to ask every website visitor, are you from Europe? Before they visit your website. That's a pretty, what's that?
Extraterritorial.
As opposed to extraterrestrial. That extraterritorial clause is a real killer.
Okay, we've got another question for Paul. So I apologize, I dropped the phone. Basic legal question. How would California enforce their state law on entities in other states or countries?
I think the enforcement actions, if they were to be taken by the California Attorney General's office, they would be in the form of, letters of non-conformance that would get sent to a business, and it still remains to be determined, how the enforcement actions will shape up. I think, as I mentioned, the Attorney General's office is still hiring staff to staff up for the enforcement of the CCPA. They have yet to pass any regulations that specify how enforcement actions would take place. But I envision that it would start with letters of noncompliance, and then in terms of enforcement actions, they would be able to levy fines against companies, and if need be, haul them into California courts for specific suits. But there's a lot that still needs to be put in place by the California Attorney General. So over the next 6 months, you need to pay attention to updates from the AG's office to determine what those enforcement actions will look like.
Great, thanks, Paul. And then on a broader scope, how are other industries tackling CCPA?
Yeah, well, it's if you've been to a website and you think, haven't I already clicked accept on this website? It's probably because they've updated their terms and conditions, their pop-ups. As I look around at all the other media sites and all the other sites that I go to, I've become very aware of just how new their pop-ups are, or how revised their pop-ups are, and And I don't, one of the things that concerned me was I don't see a ton of that in the destination marketing sites when I go there. So the consent management platforms, which are the foundation of smart pop-ups, if you will, and smart data collection. These guys are doing killer business right now, and they're doing it in other industries. I haven't seen a ton of adoption in tourism yet, but that may be. That's why we've tried to offer a consent management platform free to accelerate that response.
Excellent. Well, I'm sure, just knowing all of the rich content, and as people go back to their day-to-day and their teams to see if they're compliant and where they're at with this, they'll have plenty of questions for you guys. So we'll give everyone a moment. We have a few more minutes. If there are any other questions, just to type those in, but we'll be sending out the deck along with Cree and Paul's information. But Paul or Cree, any other closing comments?
No, I appreciate this opportunity to talk about it. I appreciate everybody joining to tackle the hard questions. We tried to make it as interactive and entertaining as possible, we did compress the accuracy and quality data points because we had so many questions about compliance there. So hope everybody benefited from it, and thanks to everyone for taking some time to figure out how to ask the hard questions.
Yeah. Likewise. Thank you.
Wonderful. Well, thanks everyone. Thanks to the Arrivalist team and Paul so much for pulling this together. And we will look forward to sending this out and connecting with you all in the new year.